I'm back to talk about the Clarett 1 case, the district court case involving Maurice Clarett. It happened that I was at the National Football League Players Association Combine Agent Seminar when Judge Scheinland's decision came down, opening the window for Maurice Clarett to enter the draft. He was at that combine training at the time. Dick Bertelsen, the head of the NFL Players Association, who's one of the most interesting sports law speakers I've ever heard, if not perhaps the most effective of sports law lawyers, although he has done very well at Antitrust in his years, said he thought there was good case law to show why Clarett would not be permitted in the draft. 900 of the 1,000 agents in the room, who were lawyers, all scoffed at that one. We all said, no way, this case is a case of a league that's a monopoly, irrationally and arbitrarily excluding someone on a rule that serves no legitimate purpose. Clarett would easily be allowed in the league, and there's no way an appeals court would overturn the trial court in this one. Sure enough, we proved to be wrong at the end of the day. The appeals court does in fact overturn Judge Scheinland, but I still have a warm spot in my heart for Judge Scheinland because I think she gets it right. Well, what's the case here? Clarett, now having been excluded from Ohio State, petitions the NFL saying that there would be an irreparable harm and an inadequacy at money damages if his request for an injunction to permit him to enter the NFL draft was denied. He makes his showing effectively by saying that the NFL is a monopoly. There is no other professional football league in North America that allows his position, which is tailback, to truly exist. Arena football has eliminated that position by and large, and the salary cap in arena football is roughly around $60,000 a player. So his position doesn't exist, and he would be forced to work for much lower pay in arena football. And besides that, it's not really a comparable league. Canadian Football League, which is on the North American continent, but certainly not in the country that Maurice Clarett lives, has a $2 million per team salary cap for 36 players, where $2 million is the average of an NFL starter. Clarett would clearly be forced to leave his home country, something not usually envisioned by the antitrust laws, and he would be forced to work for ridiculously low pay if he were forced to go to Canada to ply his trade. So let's say this. The NFL is a monopoly, at least a natural one. We're not saying they put other leagues or other divisions out of work, but in this circumstance, there's clearly an issue that the NFL is the only game in town, and Clarett has no other viable option. Well, let's talk about that for a moment. Let's say that Maurice Clarett were a really good young truck driver. He's only 18, and the union and the Teamsters Union has a rule with their employers that you have to be 21. We recognize that Teamsters live kind of a rowdy life. They travel around the country. We want some elemental responsibility. We want them to be old enough to carry a firearm, perhaps, or be able to buy liquor on the road. Not that that necessarily helps you as a truck driver, but they could have that rule. And why could they have that rule? Because no trucking company is a monopoly. There are a lot of them. So even if he wasn't qualified to be a Teamster, he could certainly work for a non-union shop as a truck driver. He could certainly seek out employment working for a UPS or something like that that would be similar. He could buy his own truck potentially and start working. The barrier to entry would not be so high that if Clarett started his own trucking company or got someone to back him, that he could do it. But certainly Maurice Clarett in this circumstance as the football player could not go out and start his own football team. That'd be crazy, right? So, and certainly not his own league. So what he's really being done is this is a monopoly with a rule, and this rule is geared to exclude people who are not 3 years beyond graduation from high school. Doesn't say you have to be in college, doesn't say you have to learn basic math, doesn't say you have to use a checkbook, but it does say you have to be 3 years out of college or high school before you can enter the NFL draft, and Clarett is being banned because he's only 2 years out. Interestingly enough, Larry Fitzgerald, who only played 2 years of college football but was 3 years out of high school, he did a PG year at a prep school, he was allowed to enter that exact same draft. So it's a very interesting dichotomy. 2 years out of high school, no NFL. 3 years out of high school, NFL, doesn't matter what you did. So Clarett is clearly being held back. Clarett's lawyers go line up deposition testimony or affidavit testimony from NFL personnel saying that he would be drafted, saying that he meets the physical criteria to be drafted. And if you watch the Rose Bowl game that he played for the national title against the University of Miami, he sure looked like he could be drafted. In fact, if you watch Clarett, you knew he was a heavy running back, and he might only get heavier as he got older. His next stop might be playing guard, actually, in the NFL, and unfortunately, after he was drafted by Denver a couple of years later, he didn't really last so long because his weight had climbed, his speed had left him, and as he got older, he just wasn't the special athlete that he was at 18 or 19. It's interesting how he peaked young and didn't keep up that level of excellence. I guess there should be an argument, or at least an idea, that you should enter the draft when you're the best you are. Some of us never have that moment. Okay. Back to the idea. Clarett sues an antitrust. He seeks an injunction. He says by being kept out of the NFL for arbitrary reasons under this rule, a rule that is not in the collective bargaining agreement, the NFL, a monopoly, is violating the antitrust laws. It is committing a group boycott against him. And he wants to be permitted to enter the draft. He seeks that help in a New York court, thinking that they would have jurisdiction over the NFL, which is the league's office is based in New York, and they would get some very player-friendly ruling from the judge. He goes before Judge Sarah Scheinlin with his attorneys, and he makes this petition. He claims the antitrust violation. Judge Scheinlin brings the NFL in on the case on a preliminary injunction stage, and she questions the NFL very hard. The NFL offers several defenses. Of course, your first defense in an antitrust action is, I have a baseball exemption. Well, they don't. They're football. So they don't raise that. But they do raise the collective bargaining, non-statutory and statutory collective bargaining exception, the labor exception, found in the Clayton Antitrust Act, which says that anything that is the subject of mandatory arm's length bargaining that a union and its employer agree on will be given antitrust exemption. The NFL makes that case. The NFL also makes the case that having this rule in place has a pro-competitive effect. So they make a rule of reason argument as well. Judge Scheinlin breaks down the rule of reason argument pretty quickly by saying there clearly is no pro-competitive effect with regard to Clarett, and then she takes on the antitrust argument, or the labor exemption argument. Clearly, because this rule is not found in the collective bargaining agreement, Judge Scheinlin says it does not get labor scrutiny. Furthermore, she says the non-statutory labor exemption is inapplicable to this situation because we have a clear monopoly here. And she says that the monopoly is the more important aspect, not the labor law. So she puts antitrust supreme and grants Clarett's injunction, allows him into that year's NFL draft, and opens a window for other similarly situated players who are not 3 years out of college to enter as well. Mike Williams, the USC wide receiver, walks through that same door. Mike Williams, in one of the more boneheaded moves in the history of sports, signs with an agent, not recognizing that this door could close by the NFL's appeal, or at least not waiting for the NFL's appeal to be heard, signs with an agent and borrows $150,000, rendering him hopelessly and permanently ineligible, whereas he might have been innocently walking through that door created by Clarett and Judge Scheinlin. He might have been able to return to USC. As it was, having borrowed the $150,000, he told the NCAA in his reinstatement hearing that he would try to pay it back once he turned pro, which seemed kind of ridiculous. Anyway, that's where we are right now. We've gotten to the decision in Clarett 1. Let's stop it. Maybe you can start on the next reel.